Hey everyone, welcome to the Legal Hour, where we come on weekly with different attorneys to talk about different areas of the law. My name is Tamika Johnson, the host. I am an estate planning attorney in the state of Georgia, where I handle estate planning, wills, trusts, healthcare directives, power of attorneys, probates, deeds, and that kind of thing. If you are in the state of Georgia, be sure to contact me if you need to get your estate plan started or updated at johnsonlawpractice.com. And today, our guest is Attorney Shaunette Stokes. And, I'm always excited about our guests because there's so many different areas of law that I am not familiar with at all. So I'm excited to talk about trademarks. About a month or so ago, we had another attorney on, Michelle Moss, who spoke about copyrights and internet law. And a lot of times people, they kind of confuse copyrights and trademarks. They seem so similar. So we didn't talk about trademarks then because I knew Attorney Stokes was coming on. We were going to talk about it today. So first, Attorney Stokes, thank you for joining us today.
Thank you. Thank you. Thank you so much for having me.
Of course. So if you have a question, this is specifically for small businesses, new businesses. I think a lot of people think that trademarks are for these big mega corporations or celebrities. It is not. And so Attorney Stokes is going to talk about that and the importance of protecting your brand, protecting your trademarks as a new business or small business, because sometimes it's kind of too late if
Yeah.
you don't do it beforehand. I'm going to talk a little bit about how I almost got caught not filing a trademark. So because there's people out there who will get you.
Yeah.
If you want to join us on camera and ask a question, the link to join us is in the comments on YouTube and the business page. So you can do that. And okay, we got a question really quick, which we'll get you to answer a little bit later on. Is this do nonprofits have to trademark? And the answer is yes. But we'll talk about that.
That's funny because I
So
have a post that's coming up talking all about trademarks and nonprofits. So absolutely, yes, Stephanie.
awesome. So before we start, just tell everyone a little bit about you, what you do, how you got started in doing trademarks. I know you do a couple of things, but what gravitates you towards trademarks, and just introduce yourself.
Hi, everyone. My name is Shaunette Stokes. I am the managing partner at Stokes Law Group. We specialize in small business law that includes intellectual property, business formation, and contract review. And we also do estate planning and probate, which also includes succession planning for our entrepreneurs. And we have just added real estate closings to our practice area. And we also do personal injury law. That is a small arm of our firm. So, what got me into trademarks is specifically my love for small businesses. As an entrepreneur, I just love to see other people thrive. And, that kind of gives me the gas to push me along the way. So, seeing other people and having these ideas, I really want to help them protect it. And I've seen entrepreneurs and inventors get caught up in, telling everyone how much they love their product or their service, and it gets stolen from them. And I want to be able to be that person that can stand in that gap and make sure that no one is taken advantage of.
Yeah, that's good. I saw something, it's not necessarily trademarks, but I saw a post somewhere that was saying one of these companies, fashion companies, what
Mhm.
they do is they look at like smaller companies, unknown companies or designers and stylists, and they take
Yeah.
their fashions and
Mhm.
they, pin it as their own. And so a lot of times, again, just being an individual or not having the correct protections,
Mhm.
they get taken advantage of or they lose out. So I'm not saying that's a trademark case, but just, people do prey on small businesses because,
No, it's
that's where all
huge.
the ideas are.
And it's not just small businesses. Back in, I want to say 2013, I wrote an article about fast fashion, just like Fashion Nova, companies like that were looking at these dresses on the runway and immediately creating copies and replicas of that fashion. And unfortunately, the fashion industry does not have many protections built in. Yes, it goes under copyright law because, of course, drawings can be considered copyright, but it's a fine line and it always gets crossed. And you see fast fashion attacking larger brands, and you also see them attacking smaller brands. No one is exempt from these companies going in, seeing your beautiful creations that you have made and replicating that within their business.
Yeah. So tell us about maybe like a major case that's going on right now, a trademark case that someone like people will be familiar with, and your kind of your perspective on. I know we talked briefly about there's a case with Lori Harvey and Kim
Mhm.
Kardashian and some other things going on. So tell us a little bit about that.
So there's a small business owner that has Skin, the actual, and there's different versions of Kim Kardashian, Lori Harvey, and this small business owner. I'm so sorry, I don't know her name, but at the moment, these three business owners have the same exact product line, which is called Skin, SKIN, SKN. There are different ways that they're spelling them, but they're all phonetically, they sound alike. So when you have consumers that are in the marketplace actually trying to find skin products, they're going to be confused, especially when you have someone such as Kim Kardashian and Lori Harvey that flood the marketplace because they have a lot of social capital. They've got followers. They have their own brands within themselves. So it's much easier to divert customers to their product lines as opposed to this small business owner. So unfortunately, it's going to take this young woman or a woman to have a lot of money to protect herself. So when it comes to actually starting a brand, you want to make sure that you have the financial capital to back and support protecting that brand, because you are not exempt from being infringed on, unfortunately. And that is exactly what's happening. And because this small business owner does not have the financial reach that Kim Kardashian and Lori Harvey does, she may have to either rebrand or fight it out. And hopefully she does fight it out and wins, because it's all about priority. Who started the brand first and who filed first? It's twofold. So you have to file first before any other secondary users. So you got to beat them to the punch. And you want to start the business first and start actually selling the products. So with
Okay.
her, she unfortunately is having to fight that.
Okay. So what is that issue? Is it the actual name? Is it the logo? Is it the brand?
It's the
Like, what
name.
is it that it's the what?
It's the name Skin, SKN, SKIN. It's the fact that although they're not the exact spelling, they sound alike. And
Right.
a lot of brand holders don't realize that if the brand sounds alike and it's not spelled the same, it's still infringement.
Wow. Okay. So you're saying that it's twofold. So what if what if someone they started, let's say the small business owner, she started hers first, her
Mhm,
company first, Skin, but she didn't trademark it. And let's say Lori Harvey did.
mhm.
Who gets priority?
So the courts consider Lori Harvey as the first to file gets priority, right? But if Lori Harvey filed before this business owner, then the business owner then has to come in, file an application, and then tell her attorney that, hey, I intend to object to Lori Harvey's trademark application in what we call the publication phase. So once she is put on notice that Lori Harvey has filed a trademark, she needs to file the trademark as well. And then when it comes to the time that Lori Harvey's trademark actually is reviewed and you're asking for the USPTO to put them on pause, put them on ice a little bit, because you want to then pull them into what we call trademark litigation. It is actually TTAB. So the trademark appeal board, all of that is separate and apart from the actual trademark process. So, and I'm my brain is leaving me for a second because I don't know the full spelling. So let me see. TTAB, meaning Trademark Trial and Appeal Board. There you
Okay.
go. My coffee didn't kick in yet. So, so with that, you'll have to, and it's a separate cause of action from filing the application. So the trademark TTAB essentially is where you've probably heard it a lot as well. They're in trademark litigation. That
Mhm.
is where it happens in TTAB, not necessarily in federal court. This
Okay.
often happens at the United States Trademark Office.
Okay. So, question. Let's say that in this particular case that we're talking about, Lori Harvey, she filed her application for a trademark. Everything went through. The small business owner, she didn't object. She didn't put them on notice. She didn't file her own trademark application. And then maybe 6 months later, she finds out. That's when she finds out. Is it too late for her at that point to file and then claim that she started this? This is her brand. This is her name first.
So the proper venue then would be federal court. So you would file federal lawsuit for trademark infringement, and this business owner would have to actually show proof that she was priority to get a court to order that she actually has showed valid proof that she had common law trademark rights well before Lori Harvey did. And
Mhm.
a federal judge will then, of course, take away Lori Harvey's rights to her trademarks. And then she would be able to file for her trademark.
No,
You kind of
that
need to
sounds
clear the
expensive.
road.
It sounds expensive.
It's very expensive, and that's why, you have so many trademark attorneys out here trying to educate the masses because we know the ramifications and we know how expensive it can get if you let this linger too far. If you've let so many people flood the marketplace with a similar brand name and you've done nothing to police it, it's going to cost you a ton more to protect it at the back end than you did if you preemptively just filed your trademark, got it protected prior to you releasing the brand, and you have that, safety and security knowing that even if someone does infringe on you, you have the valid trademark certificate to, and actually sue them for trademark infringement, because it's one thing to sue for trademark infringement because they have a trademark certificate, but it's another thing to actually hold the trademark certificate and still sue someone that is infringing on your valid trademark.
Yeah.
So you want to have that right, and you want to be able to police it.
Yeah. And the fact that the application process or the fee for the application is really kind of nominal.
It's very
Um,
nominal compared to attorney's fees and
yeah.
litigation fees.
Yeah, I don't want to say the wrong fee. So, but how much does it cost? Because that's, a big deal for small business, new business. How much does it cost to file a trademark application?
So I've seen the ranges between $2,000 and $5,000, and it just depends on the attorney, what you need out of that package. I would honestly tell anyone that is in the market for a trademark, shop around, see what you need. There are different attorneys that are offering more in their packages. Some attorneys will not review their application after it's been filed. So that's going to be the lower end. So after you file the trademark application, it'll probably be submitted, and then that's the end of the transaction. Whereas you have another attorney that will follow you through the actual entire process. You have monitoring included in the package. And that's something that you really want, because you want the attorney to hold your hand and walk you through that process.
Gotcha. Okay, so we're talking about trademarks. Let's actually define what a trademark is. So tell us exactly what a trademark is.
So, trademark is just a source identifier. So, that could be your brand name, it could be your logo, it could be a song or chime, or even a sound that is related to your brand. And most people don't know this, but a color can actually be a trademark. Anything that identifies the source of the product or service is a trademark. Whereas with a copyright, it's your content, everything that you create, the inner workings of your business, like your business plan. If you're a caterer, your recipe books, or if you are a actual restaurant, the recipes for the meals that you cook, that could be considered trade secrets or copyrights. So it just depends on what you're actually wanting to use the actual content within your business. For instance, with the restaurant example, you have the choice, they have the choice to keep it as a trade secret or to copyright it and then reproduce it in a form of a cookbook. So
Mhm.
you want, with copyrights, you want to be able to reproduce content. And that's the thing. You have to think about, if this is this something that I want to reproduce or keep a secret. So that's how you decipher if you want to keep it as a trade secret or a copyright. And with
Gotcha.
trademarks, it's just, and trademarks, I'd like to say this, with the logo specifically, can be a copyright and a trademark because the logo can is a drawing. So you want to make sure that you get both a trademark and a copyright for your logo.
That's interesting. I had never even thought about that. Like
Hmm.
doing both of them. Okay, so what about, let's say you have like a business model or a framework. Let's say you're a speaker, you have a framework that you teach. Is that considered both copyright and trademark, or one or the other? Does that make
So
sense?
if you have a curriculum that you have created, I have a lot of speakers, a lot of coaches that come through my door. And what we do is copyright the curriculum. And if they have a fancy name for that curriculum, we'll trademark it, because
Okay.
you want to be able to, one, protect the name of it and not let everyone and their mama have that same exact name. And then with the copyright, the actual curriculum, you want to be able to reproduce it, maybe sell it to schools and have them teach that copyright or the curriculum in their schools, and you get some royalties from that. It's how you want to package and what you want to do with it overall.
Okay. And so I just want to clarify, because I know we have a lot of small business owners who will be watching in whatever
Mhm,
area. And so the name of their business,
mhm.
especially when they grow and they want to get known, that's something that they should definitely trademark, correct?
Yes. So the name, your taglines, slogans, anything that your clients associate with your brand.
Gotcha. Okay. So I'm just gonna tell just really quick, like my my situation where I almost kind of like got caught. So for people that know me, I also I own a matchmaking agency. And
Oh,
so
okay.
when I started last year or two, I just kind of came up with the matchmaking attorney, because I'm an attorney, I own a
Mhm,
matchmaking agency, matchmaking attorney. It was really easy to identify. And so one day I was talking to a friend of mine. I went to her office. She's another attorney. And she was introducing me to one of her partners. She was like, "Oh, you know Tamika." And partner was like, "No, I don't." She's like, "No, she's in that group that we're in together." She was like, "No." And she was like, "But she also has a dating agency." And she was like, "Oh, you mean the matchmaking attorney?" And I'm like,
mhm.
if that's how she knows me
Yep,
and other people know me
that's how
like
that
that,
works.
that was like, okay, I need to go
That
ahead
is
and
your
trademark.
trademark.
Yes, because there's other attorneys that have matchmaking agencies
Matchmaking,
out there, and
really?
I did not know that. But yeah, so that was one. And then at the time when I came up with it, I just kind of came up with the name, right? So when
Right.
I went to go, I was like, I need to go ahead and get a domain for this for a
Mhm,
matchmaking attorney. And again, it was taking like maybe a couple weeks before I even started searching.
mhm.
So you can tell when it happened, and I was like, okay, see, somebody's out there on the prowl.
Yeah, yeah.
Someone, I already took that, because that's big money as well, your domain
Mhm. A good
on the web app.
indicator for that is, yes, your domain. So a lot of people question whether owning the domain means that you have the federal rights, and no, it doesn't. Internet
Mhm.
existing on the internet is not the same as actually having the federal right to use your trademark. So even if you were able to secure the domain name, that the buck doesn't stop there. I always tell my clients that's step one. Get that domain name, but then
Mhm.
call me for the trademark because that's important. As soon as you start, offering these products or services, you want to make sure that no one beats you to the punch because you want to be priority. It's just like going to the DMV, right? When you go, you want to go before everybody else, get in line before everybody else because you don't want to wait so long. And that's
Mhm.
the idea and the thought process that you should have when it comes to the USPTO. It's just like the DMV. If you don't want to wait in line, you better file early.
Right.
And that's the, that's the same mindset that you should have. File early. As soon as you create your product or brand or service, file immediately. And I do know that we have a question about, do we need an attorney to file? And
Mhm.
I'm gonna be honest with you. No, you don't need an attorney, but you would. I certainly would behoove you to hire one because going to file a trademark application is just like going to court by yourself. You don't want to
Mhm.
do it because there are attorneys, actual attorneys on the other side of that application. The application is it's unfortunately uh, easy to the public in their eyes, but there's a lot of legalese that they overlook. They think that, certain terms on the application means one thing and it doesn't. Like specimen. Do we know what a specimen is? And if you're not a trademark attorney, you probably won't even know what that is. Am I
Okay.
still there? Did
You
you lose?
are.
Okay. So I recommend that in order for you to have a seamless and probably very inexpensive process, because one thing a lot of pro se filers do, what that means is if you file on your own, they get a lot of objections or rejections as well. So objections in the publication phase and rejections in the initial phase of the trademark filings. So you want to make sure that you're backed by someone with the legal knowledge that can protect you. Because no attorney is going to file that application without letting you know what you're headed up against, because we do extensive research. We make sure that one, the trademark is actually a strong enough mark to pass through the application phase. That's step one. And then step two, we actually determine and compare your mark with other marks within the USPTO and brand holders outside of the USPTO. And we will give you the green light as to whether or not you should proceed or proceed with caution or don't proceed at all. And it's up to the client to make that determination. But as the attorney, I'm giving them an informed decision. It's just like going to surgery. You may or may not have, some hiccups along the way. There may be somebody that might come up in the trademark phase, the application phase, that the examiner may compare your mark to, and that might be a hindrance to you. But that's something that you would have known well before you filed that application. Because for me, in my conversations with my clients, I have a strategy. In that conversation, we come up with a strategy. I ask them questions about their products, their services, and if it is a huge bar, like if there's a competing mark already out there at the USPTOs in their system, in that conversation with the client, I let them know, hey, it's somebody out there. Either we can approach with caution, and I'm going to tell you it's going to be an uphill battle, or you can rebrand. It's up to you. But I'm telling you, you have two options. And it's always up to the client. And if they so choose to rebrand, then they get the opportunity to rebrand and have the knowledge and understanding that this brand name is a little bit more secure than the prior brand name that they picked.
Okay. So, what are some common rejections that you may encounter, especially for people who file themselves without an
Mhm.
attorney? What are some common objections that or rejections that you see
Mhm.
or heard?
So it is likelihood of confusion, meaning the phonetic spelling or phonetic saying of the word. The spelling's not the same, but it sounds the same. It is a failure to function, meaning everybody's using the term, you can't take it. A good example is, I know LeBron James is fighting for Taco Tuesday, and they're just saying it's failing to function. You can't take a term that everybody's using, you know?
Mhm.
And one final thing that always comes up is specimen refusals. That's huge right now because at the USPTO, what they have been facing has been a lot of companies from overseas have been sending fake proofs of use, like mock-ups, digital mock-ups, and it looks like the product is being used in commerce, but it's not. It's just a computer generated photo. And so you're actually having an issue with actual users. I have to tell my clients, hey, show your hands in the picture because it's not a digital mock-up if you have your hand. Put your face in it a little bit because they really will say, no, that's a digital mock-up. And I have to tell them, I'm fighting with these people. This is not a digital. You see that lady finger in there? It's not a digital mock-up.
Right.
So that it's really all about honestly a subjective measure to what the USPTO feels is a proper specimen. And I know what they're looking for. And most, lay people, non-attorneys don't know what they're looking for because they haven't filed the amount of applications that I filed. They don't know what each examiner is looking for. And
Yeah,
that's huge.
it's not just non-attorneys. It's attorneys
Yeah,
who don't know anything about trademarks as well.
yeah, yeah, that's true. That's
So
true.
yeah, I think a lot of times we're like, well, I can figure it out. But the reality is,
Mhm.
well, I have no desire to learn anything else new in my life at this point
Not
legally.
after law school and practicing law for a certain
Yeah.
period of time. Your brain is overloaded.
Yeah. So it's just yeah,
Yeah.
just go to the professionals. Go to the people who specialize in it.
Yes.
So there's another question, and I'll let you answer it. Do you have
Mhm.
the no, not that one. So when you register with the state, your company, is that not enough?
No, it's not enough. So when you're registering in the state, say Georgia, and you exist as, we'll say, Dove shampoo, right? Well,
Mhm.
there's a huge company that owns Dove shampoo in a different part of the world. How do you know that they exist? Obviously, with this example, it's a large popular brand, but if it's a mom and pop store that has a federal trademark, how do you know they exist other than filing, researching, doing the actual research that this mom and pop store owns the federal rights to this name? Because that's huge. If someone owns the federal right to the name, then you in Texas, Georgia, Florida can't use it. And each Department of State, so in Florida, we call it the Division of Corporations. They don't cross reference other states' names, business names. They only reference their own database. So, what you're given in your particular state is the common law right.
Mhm.
And that only exists in that state. So if
Mhm.
you're seeing your business grow and if you want to see your business grow, it's not just if you're seeing, if you want to see your business grow, you want to get a federal trademark because you want to be able to do business not just in your state, but across the United States and overseas.
Yeah.
So yes, get a
And
federal.
then a lot of times when you're filing with the state, you're filing for liability purposes or protections.
Mm-hmm,
You're filing for, the LLC or the partnership or corporation, and that just kind of limits your liability as
mm-hmm,
opposed to protecting anything else that deals with your name or brand or anything like that.
absolutely.
So next question, when you apply for your business with the state, do they research the name and registration to verify trademark? No. So you just
Mm-hmm,
kind of answer that. Yeah,
mm-hmm.
trademarks are federal,
Yep.
and what you do with the state is obviously with the state. So
Right.
you're based out of where? What state are
Tampa,
you in?
Florida. I'm in Tampa, Florida.
You're
So
in Florida.
Florida, I do accept um businesses within the state of Florida for business formation
Mhm.
and for nonprofit as well. But outside of the state of Florida, I do trademarks and copyrights for those business owners.
Right. Okay. So yeah. So again, just to clarify, the setup of your company or
Mhm.
organization that is state, but copyrights, trademarks, patents, those things are federal, and so that
Yeah.
those can be handled by an attorney in any state because those are
Yes.
governed by federal.
And with the addition to that, I also do tax exempt formation for most business owners. So Tax exemption is also federal because I don't do the state. If they're not in Florida, I don't form the actual corporation, but I do the tax exemption filings for nonprofits.
Okay. All right. Gotcha. Okay. So let's go on specifically just to talk about and I know you've mentioned it like here and there, but what is the trademark process? They come to you and client decides, okay, everything looks good according to you. We're
Mhm.
going to go ahead and file this application. What does it look like from there?
So after we filed it, well, prior to filing it, we get the clients all of their intake paperwork, and we will do a comprehensive deep dive on their mark. So we'll let them know if there is a mark that exists not only at the USPTO's database but just common law, so they know who their competitor is in the marketplace. And we will issue a memorandum just letting them know, hey, this is what we found, this is what we believe will be a hurdle or not. If there are no hurdles, we'll let them know, and they'll let us know if they want to proceed. So once they've given us the green light, we will apply for their trademark. After we have filed for the trademark, it takes about now 9 months for an examiner to even touch the application because they are so behind. And it's going to be a very long process, but they had to hire 70 new attorneys, by the way, to actually catch up. So once they've actually touched your application, then they review it the same way that I review it. They'll make sure that there's no infringing competing marks out there at the trademark office, and they'll also make sure that your mark is strong enough to go through the process, because one thing they look for is descriptive terms. They want to make sure that you're not just describing the service that you're offering, which is, I'm a trademark attorney, or I'm a shampoo girl. Like, these are things. And if you are describing it, what they can do is put you on the supplemental register and not the principal register. And I can go into that in a separate part of the conversation. But once they have done the actual review of the application, they will issue either an office action to myself or to the pro se applicant. And if they are actually represented by attorneys, they actually call us and say, hey, can you do XYZ for this application? I'll give them a verbal, and they push it along. That process is not the same for, non attorneys. So they don't get that leisure of a phone call. So after they have done the preliminary review of the application, then it goes to what we call the publication phase. And the publication phase is, I liken it to getting married. You know, is the USPTO telling all of the trademark holders, hey, this person here is entering a union with this mark. Is there anyone out there going to object? And speak now or forever hold your peace. So actual trademark holders with a similar name, they feel that this person is infringing on their mark, or if they feel that by this person entering into the marketplace with a valid trademark would cause confusion, they have the right in that opportunity to object to their trademark application. So if they object, then again, it pulls them out of the trademark process and into trademark litigation. So if they don't object, then my client gets their actual trademark certificate. And I'll say that the likelihood of objection with my process, because again, I don't put you out there knowing that there's going to be someone with the same mark. So the likelihood of objection is probably about 90% they don't object to. But then you have those large companies that have trademark watchers just sitting on their computers all day watching the official gazette, just waiting for someone to file an application with a similar name. Because they do have companies like that. They just sit there and watch it. That's their day-to-day job and duty. So you want to be careful with that. You want to make sure that when you're creating a brand name, it's not similar to anyone else's, especially a large company, because they don't play at all.
Yeah. So I would think that that's after the publication piece. Like that's when it's important to have someone monitoring it, because I'm
Mhm.
thinking if I file something, I'm not looking at it. It's
Yeah.
like, when we file something in the local paper, like
Mhm.
how many people are
Who looks
actually
for it?
looking in the
Right.
notices, right? Once you
Right.
file something, but there are like a small number of people, like you said, or corporations, or
Mhm.
that's just their job to look at them. But most people
Mhm.
don't. And, having an attorney or having a whoever you choose to do that, I would think that's the point. Like, that's where it's important to have someone to actually monitor, because I
Mhm.
wouldn't. I'm
Right,
like,
and
I
that's
filed it, I'm good.
twofold.
I'm done.
It's twofold. It's having them monitor it, one, during the process of your trademark application, and then having an attorney monitor it ongoing, like, actually having a subscription to a service where the attorney monitors your trademark because you want to be on notice. I had a client about a month or two ago. We have trademark watching on hers, and you got Toys R Us trying to infringe on her trademark. We don't play that. So,
Wow.
we have to advise the client, "Hey, this is what's going on. What do you want to do?" And they can make the decision if they want to proceed and, pay for the service to have them pulled in trademark litigation, or you could just watch and see what the USPTO does with that trademark application. But it is up to the trademark holder to police and monitor their trademark, because it's one thing to get the certificate, but people will still go crazy with your brand if you don't stop them, you know?
Mm, yeah. So let me ask this: with that particular case that Toys R Us is trying to infringe upon your client's
Mhm.
trademark, what happens? Let's say, okay, your client objects, files the objections. Now what? Let's say, let's say um, that you didn't see it. You didn't
Mhm.
find that out. You didn't find that at Toys R Us, and then later on down the line, you saw it in the public
Mhm.
somehow.
Mhm.
Um, what what is the benefit of your client having that trademark? What can she do? What is the compensation? What are the, damages, penalties, all of that? If you find that out later and file something.
So actually, the benefit of having a federal trademark is, number one, the USPTO is going to stop them first. The USPTO is
Okay.
going to say, "Hey, no, you can't do this. I know that you're a large corporation, but this person already has one in the same industry as you." So absolutely not. So that one, if they file an application in the same category, the USPTO will do their job and stop them at the door. They can't sit with you, essentially. And if they do find a way and they coerce themselves in the door to sit right next to you, then you can file a lawsuit for infringement, you know?
Okay.
But again, the benefit of having a trademark is allowing and getting that assistance from the USPTO, where they will bar any subsequent applicants from using a similar name as you. And that's huge, because
Yeah.
they're kind of your little personal assistant in a way. They kind of can monitor it while you're not even watching, because she had no idea. The only reason that we got put on notice in this instance is because they got an office action, and the examiner said, "No, you're not doing that." And we were put on notice. So
Okay.
you want to actually have a trademark in the USPTO's database, a valid registered trademark, so that the examiner can decline and deny any subsequent registrants on your behalf.
Yeah. So I want to go back a little bit towards the nonprofit question that was
Mhm.
asked earlier. And we started talking about it a little bit well before the show. And you're so young, you don't even remember
I told
when
you
it
I was
happened.
born in the 80s.
This is when all this took place, kind of, sort of. So, for anyone who was like my age, maybe a little bit older, back in the day, we all knew wrestling as WWF. We grew up hearing WWF. We knew exactly what that meant, and that was the wrestling worldwide Wrestling Federation.
Mhm.
And they've been using this since like the 80s at
You
least,
have
right?
been.
So early 2000s, and I remember the case. I was actually working at a law firm. I wasn't an attorney, but I was working at a law firm. And I remember just seeing this case where there was another organization. It was a nonprofit. It was called World Wildlife Fund, so WWF. And so they filed, and I'm using the wrong words, I'm sure. They filed a claim
Mhm.
against the trademark of WWF. And which was kind of crazy to all of us because that's all when we
'Cause
thought
they've
WWF, we
been in
thought
business.
wrestling. But this
Yeah.
nonprofit was like, no, it's ours. And the next thing I know, WWF is now WWE. So clearly they lost.
Mhm.
They lost the right to be able to use WWF. And so that to me, shows how important it is. So it wasn't even the same name, but it was the acronym
Yeah.
that needs to be trademarked. And you don't think that, but if that's how you're known, that's actually trademarkable, if that's a word.
Mhm. I mean, sometimes,
Yeah.
I'll say this. I'll say this. Sometimes they lose, and sometimes they just take the L and walk away, right?
Mm,
So, and what I mean by that is because I've told my clients, listen, you have this company, this large company with a lot of money. This is the cost to fight it, right? And this is the cost to rebrand.
mhm,
Which one do you choose? Because one, the cost to fight it, you have to show that first.
mhm,
You were first, and you're gonna have to go through all of your paperwork. That means your filings through the state to get all of your paperwork done, your domain filings, all of that is evidence. And it's basically you're trying to show the USPTO a timeline of existence and use. And you're wanting them to show that same timeline, and you're hoping and praying that they can show use after you, because
mhm.
it doesn't come up until discovery. Now, what is made to the public is activity on social media, activity on the websites, things of that nature. But we don't know when that person starts conducting business and actually having sales in their business, because that's use in commerce. So sometimes people make a decision on their own and not fight it. They will just say, you know what, WWE it is. I'm gonna just
Yeah.
rebrand, because it probably was cheaper for them. And
Yeah.
what did it do? Not It didn't have much of a social impact on the brand, did it? I mean, we was like, "Oh, okay, they changed their name." It's still the same company,
Yeah.
right?
It was a
So,
great commercial when their commercials came out. It was like, "Get the F out of here."
yeah,
And it was
see?
like it was amazing. I know that person who thought of that, like they got a crazy bonus for thinking
Right,
it. So it was
right.
genius. It was genius.
Because it's cute, it works with a rebrand, and,
Mhm.
sometimes companies need a little rebrand. They need a little, touch up. So it benefits them sometimes, but it can hurt them as
Yeah.
well, because you have created a lot of goodwill within
Mhm.
the community, and a lot of people know you as that one brand. So when you change it, it's just like, what's this? Just like no shade. I went to FAMU, and BCU. I promise you, I still have a hard time calling them BCU, Bethune-Cookman University, because they've rebranded. My entire life was BCC, right?
Mhm.
And now they're BCU. It's two different, same company, same organization, different brand.
Mhm.
And it's a matter of getting your consumers or the public used to your new brand name.
Mhm. And I think it's a bigger deal now because we Google everything. And
Yes.
so if you're thinking of one thing and you put that name in or whatever it is, the acronym, one thing's going to pop up or another. And so it's important from that standpoint. But back in the day, we didn't have social media. So when we're talking about something, you kind of knew what you meant and how, whatever your
Mhm.
search was, your search might've been driving to the headquarters or just watching it on TV. It
Yeah.
wasn't as big of a deal, but now we Google everything. And so, it needs to be the right name.
Right.
Making sure when people do a search on your company or whatever it is that you're pulling up and it's not another company. Like, so
Right.
it's not the small business owner, you're looking for the small business owner, but Kim Kardashian's, brand is coming up
Mhm.
or Lori Harvey's and when you've
And
worked so
another
hard.
thing I would also like to add, even if you're doing a preliminary search for your future brand name, do alternate searches for different spellings for that name, because like the example with the Kim Kardashian, the Lori Harvey, and that young lady, her name, those are three different brand names with three different spellings, but they sound the same. So
Mhm.
run the search with the different variations of how that name can be spelled out without the vowels, with vowels in there, anything. You want to make sure that you search that. And then don't just limit your search on the first page, because some people don't have the best SEO. They might exist on page 2, 3, or 4, but they got that federal trademark.
Right.
So you want to make sure that, you do the proper research, and don't
Yeah.
just limit yourself to your state. If they exist in a different state, that still means that they have the rights to a federal trademark.
Right. Now, tell us a little bit about the difference between a trademark and a service mark, and how you use that in the operation of your business.
So they're one and the same in a sense. Trademarks are for goods, and the service mark is for the service, but they're all going to be a trademark application, but you're just offering a service with your service mark.
Okay, because I don't often see SM, the service marks, but
Yeah, you're
we
not.
often see, TM for trademarks.
Mhm.
Okay,
Yeah,
so I didn't
you
know.
don't have to put TM on things. I tell clients, yeah, you can do it. You can put TM next to your brand name, but the thing that you're striving for is that big R in a circle. That's it. That's what you want. And if you're striving for a copyright, that's big C with a circle. But yeah, you can certainly put TM, SM next to your brand name. You're essentially putting people on notice that you intend to file, but it doesn't have any legal backing. And you can't go to court and say, Judge, I put SM and TM next to my name. They knew it was real. No, that ain't how it works. No, the
Okay.
judge will not have your back on that one.
Okay. So what would be the benefit of even doing that if it doesn't really mean anything by the time you apply? So I'm
Just go
gathering you use that before you use it before you apply,
Mhm,
and during the application process, but it's just for notice purposes.
mhm. Yeah,
Okay.
you telling them back off. Don't play with me.
Okay. Don't play with Miss Stokes over there. Is there anything else that you'd like to add, as advice to new business owners or startups or just small businesses in and of itself in reference to trademarks?
Absolutely. One thing that I know that a lot of new business owners don't think about is that trademarks is not just a one-time thing. You want to make sure that your trademarks is your process. Having trademarks get registered on a yearly basis should be a part of your business processes. You are adding new services to your business on a probably monthly basis, and you want to make sure that you tell your attorney, keep them informed, make them your bestie if you can, let them know any new projects that you have going on. One thing that I do for my clients, and I'm starting to do back again, is a lot of my trademark clients and my business clients, I offer a free legal audit for them, after we've done their trademark, so that we can kind of get the idea of what else in their business needs protected. And I will let them know, hey, these are things that are protectable, and let them know, give them an action plan, so to speak, and see if they want to follow it. And it's up to the client to do so. But I want them to be in the mindset of actually running and operating a business, and knowing that protecting that business is not just a one-time thing, it's an ongoing thing. And I
Yeah,
think everyone that's listening should know that.
yeah. And I just want to reiterate something that you said earlier. As your business evolves, if you have an article on your website, you all can definitely check out stokeslegalcounsel.com just to see the things that she's written. You have a lot of good information,
Thank you.
for small businesses specifically. But there's an article that you talk about, the evolution of Starbucks and the
Mhm.
evolution of their brand and their logo,
Yeah.
and just kind of lets you know they started off with one logo, and they have the one
Mhm.
that we all know and identify as being Starbucks. But for whatever reason, as they've grown, they've changed, and
Yes.
that's okay.
Yes, it
Sometimes
is
it's
okay.
good.
Change
So
is
even though
all.
you have that marriage, that analogy you gave,
Mhm. Sometimes you gotta walk
sometimes you
away
get
from that
divorced.
brand.
Right.
Yes,
Get
just walk
divorced.
away.
You get a new marriage.
Right. And if you go and look at that article, you'll see how technology has changed and how graphics just look so different. And
Mhm.
I don't know if I want to be stuck with my graphics from 1992. Like,
Right.
no. Imagine starting our businesses 20 years ago and people thinking we should be stuck to our logos. No.
Mhm.
Do you know how bad technology was 20 years ago?
Right.
I don't want that type of logo. So I would rather, grow with time, and I don't want to pigeonhole myself and stick myself to one type of brand style. I grow as a business owner, my
Right.
aesthetic is going to grow, my taste is going to grow, and I'm going to change. And so will my brand. And it has over time. My colors have changed from blue to green. I got a different logo, and I'm okay with that. And I think that people should be okay with, growing and flowing with their brand and being okay with walking away from one logo and filing another application for a new logo.
Right. Now, is there a renewal process that once you have been granted the trademark, what is the renewal process and how often?
So it's about the 7 or 8 year window. Sometimes six, they'll say, "Hey, it's about that time," and I'll start telling my clients, "Hey, it's that time. Are you still in business? What are you doing?" A lot of my clients have walked away from those projects and started new projects, and that's okay. They decide to sell their company. That's a conversation we have in that moment because, again, you have a federal trademark to your business. So you can do whatever you want to it. You could sell it, you can close it down, you could do whatever you wish. But it's all about making sure that you maintain that mark. So if you are still in existence within that business and it's been 8 years, you have to show them that one, I'm still using that same exact logo that I applied for. No changes have been made. Otherwise, if you like, much like Starbucks, went from the full bust of the mermaid to just I'm sorry, the full body of the mermaid with the legs and just to the bust of the mermaid, then that's a rebrand. And the USPTO is going to tell you, that logo that you applied for initially, you're not using that no more. So you can't tell other people from stop other people from using it.
Right.
So just understand that any small change within your business to your logo is going to impact the protection of your brand. So if I'll give you an example, if I chose to protect the color of this logo as gold and I decided to change it to green, now that's a rebrand because I am no longer operating with the gold logo. The world knows me with the green logo. But if
Right.
you choose to file your application as a black and white logo, you get the freedom to change the colors to whatever you want to.
Wow.
So these are conversations you want to have with an attorney because you want to know what things you could put in place to kind of give you some freedom and flexibility with your brand. And those are conversations I have as well with my clients with respect to the logo being separate from the word mark because we do that. We file our logo separate from our word marks because one thing is you're going to eventually change logo but not your
Right.
brand name, right? Starbucks is a great example. They never changed the brand name. They may have dropped coffee, but they still are Starbucks. That logo has changed time and time again, but the brand name is never. So you want to make sure that you have that one baseline level of protection, which is your brand name that you'll never change. And as you're evolving and growing as a business owner, you have the freedom and flexibility of changing your logo and filing new applications with that change of logo.
I'm always just blown away about how so detailed certain things are. Um, just different areas. So that is really good. And can I say, I did not know that the Starbucks logo was a mermaid. I had
Yes, it
no
was.
idea. I
It's
just thought
pretty
it was a
big.
woman on there. I
Mhm.
didn't know it was a mer. That's so funny.
Yes,
Did not know
it's a mermaid.
that was a mermaid. That's very interesting. So, thank you so much for coming.
Thank
I do
you
want to
for having
say,
me.
you did mention that the USPTO is hiring 70 attorneys. So
They
if you're an
did.
attorney that has, I guess, experience, I don't know if they're looking for experienced,
I'm not
um,
sure.
but it's definitely something to look into.
Yes.
Um, you're interested in that or have the experience.
Yes, because
Again,
my applicants need help, and they still pending over there at the USPTO office.
so go ahead and apply. Just go to their
Right,
website,
right,
USA Jobs or whatever it is.
right. Something.
Yes. Thank you so much. Again, if you
Thank
want to get
you.
back with Attorney Stokes, her website is at the bottom. I'll also leave it in the show notes if you're watching this on the replay. Thank you again. Have a wonderful day, and we will see
Thank
you next week.
you.
And thank you for joining us.
Thank you for having me.
Sure.